Cormac Cullinan. I practice as an environmental lawyer in Cape Town in South Africa, and I'm both a friend of Alex and a colleague through the Rights of Nature movement. In fact, we met a long time ago in Ecuador, approximately 15 years ago, when we were founding the Global Alliance for the Rights of Nature. So it gives me very great pleasure to be invited to open this book launch of Alex's. I have a huge respect for Alex, not only as a person, but as an academic. And this book of his really is a great work. It's a great work of scholarship. It's a great work in terms of breadth of vision and understanding. And I think it's a really, really important contribution to deepening the understanding and the discussions around this subject. So I know that Alex has put an enormous amount of time into this book and scholarship, and it really shows. And I'm really looking forward to hearing him discuss it with us tonight. So Alex is going to make a presentation about the book, and then we'll have a discussion afterwards, and I'll ask him a few questions about it, and perhaps if there's time, there might be questions as well, I hope. But without further ado, may I introduce Dr. Alessandro Pelizzon, the author of this fantastic book. Thank you, Alex.
Thank you, Cormac, for the lovely introduction. And I will briefly share the slides of... is everybody able to see the slides? Can you...
yes,
I can see the chat. Yeah, perfect.
I can see them.
Perfect. Thank you. Thank you very much. So welcome, and a very happy Earth Day to most of you. To those of you who are already in the 23rd of April, happy Earth Day for yesterday. Thank you for joining at these very disparate times. I know that people are joining from all parts of the world. I really salute those who are joining from Australia. It's 4:30 a.m. here, or just slightly past 4:30 a.m. here. Before I begin, I would like actually to welcome you and wish you a very happy Earth Day by first acknowledging, through a practice that is common here in Australia, the practice of acknowledging the country, capital C country, that we are all inhabiting today. Now, country is an Aboriginal concept that has been introduced in the popular discourse maybe 20, 25 years ago. And in acknowledging country, I want to acknowledge the country that I inhabit, which is the country that the ancestors have entrusted the Marakwal people with looking after. In so doing, I always acknowledge the challenge to any hegemonic claim to this country. But country for an Aboriginal tradition is more than just a geopolitical entity. In the words of Deborah Bird-Rose, country is the nexus of identity and interconnectedness. It's that moment in which individual identity and social connections, social more than human connections, interact and intertwine. And so, in the words of one of my mentors, Annie Barbara Nicholson, country is the total sum of all the beings and all the phenomena with which we share this space right now, this space-time right now. More than that, country is the total sum of all the relationships with and among all those beings and phenomena. And more than that, country is the total sum of all the stories, the narratives within which these relationships are contained and construed and maintained and carried forward. And so it is with this in mind that I want to pay my respects to the custodians and owners of all those stories. The ones who are generally called the elders, the ones who were, the ones who are, the ones who are yet to be. And I want to pay respect to the elders in the room today. And since country is not just a place in space, but it's also a place in time. By acknowledging country, I want to acknowledge your presence here today and our relationship for the next hour and a half, 2 hours. I really am grateful for your presence here, and I hope I will be able to share some of the insights, the the learnings that I did in approaching this topic and then writing this book. This book, as Cormac mentioned, is the result of more than 15 years of work in the field of what I call an ecological jurisprudence, and of 10 years prior to that of working in the field of comparative law and legal anthropology. So my name is Alessandro Pelizzon. I was schooled and raised in Italy, and I moved to Australia 20 years ago at the age of 30. And when I moved to Australia, many things happened. I immediately knew how to cook on the barbecue. I wasn't as bored as I was before when watching cricket. I understood the rules of this almost unknown sport known as AFL. But the one thing that didn't happen when I came to Australia was the shift of the accent. Although my accent has a little bit of a twang of Australia, but it's still quite Italian. And so what does that mean? Well, it means that sometimes my words may not be understood as clearly because of my accent. I'll give you an example. So whenever I teach, or I used to teach legal theory, I started by telling people about the nature of anarchy. Anarchy, often conceived as the space of chaos and social disorder and confusion. But I often explain to my students that anarchy in the literal sense, in the Greek etymology of the word anarchos, means a place or a space without leaders. And in order to have a space without leaders, one has to have perfect and ultimate rules. And therefore, anarchy is not a place of chaos, but rather it's a place of perfect order. And I remember at first when I started explaining this, I remember a student saying, yeah, but what do animals have to do with that? And this puzzled me for a while. It puzzled me because until I realized that when I speak of anarchy as the place of chaos and social disorder, I think of the riots that we witness or the violence that we witness often on TV or in the stories that we hear. But this is what I think of when I speak of anarchy as a space or a place of chaos and social disorder. But what people hear often is anarchy as a place of chaos and social disorder. And so if at any point throughout the presentation, anything that I say doesn't make any sense, please blame it on the accent, not on me. Now, with that in mind, I'd like to take you on a journey, on the journey of the discovery and the emergence of what I call an ecological jurisprudence. And like all journeys have to have a beginning. And I would like to propose that the beginning of this journey will be a momentous lecture by Professor Christopher Stone of the University of Southern California in 1972, a property law lecture, which he concluded by asking what was then, and still is, a very provocative question. Should trees have standing? He writes, throughout history, there have been shifts in a cluster of related property variables, such as what things at various times were recognized as honorable, land movables, ideas, other persons, slaves, who was deemed capable of ownership, individuals, married women, the powers and privileges ownership conveyed, and so on. It was easy to see how each change shifted the locus and quality of power. And so I wondered aloud, reading the glazing skepticism, what would a radically different law-driven consciousness look like? One in which nature had rights. I supplied my own answer. Yes, rivers, lakes, warming to the ideas, trees, animals. I may have ventured rocks, I am not certain. How would such a posture in law affect a community's view of itself? This little thought experiment was greeted quite sincerely with uproar. End of quote. What prompted Professor Christopher Stone to write this momentous article was the proposed development by the Disney company of a ski resort in the Mineral King Valley of the southern Sierra Mountains. The Sierra Club, the long-term self-appointed protector of the region, tried to stop the development. And filed an injunction which made it all the way up to the Ninth Circuit, which initially argued that the Sierra Club had no standing to bring the question to the court. Standing meaning the capacity of an individual or an entity to act in a court of law to protect their own interests. And the Ninth Circuit Court argued that since the Sierra Club did not allege that it itself was aggrieved or that it itself was adversely affected within the meaning of the rules of standing, then it did not have standing and therefore the right to act in court. This case, then, the appeal made it all the way up to the Supreme Court in a well-known case known as Sierra Club and Morton, the then Secretary for Interior, which affirmed that the quote, that the injury in fact test requires more than an injury to a cognizable interest. It requires that the party seeking review be himself among the injured, end of quote. So in other words, since the Sierra Club was not directly injured or affected by the proposed development, it didn't have standing. But, Professor Stone argued, something was being damaged. Something was being aggrieved, that is, an old-growth forest that would have been destroyed by the proposed development. And therefore, since standing was the necessary prerequisite to protect that which was to be damaged from being damaged, then maybe the trees themselves, the forest itself, should have had standing. Now, why was this contentious? Why is it that what was a clear damage, the destruction of an old-growth forest, was ecologically visible, but legally invisible, or at least legally irrelevant? What is it that made it so? What is it in the legal consciousness of the time that made it legally invisible? What is it, in other words, in the particular lifestyle of the modern contemporary dominant society that makes these particular environmental damages legally invisible? Perhaps this is due to a particular worldview, a particular way of conceiving our position in the cosmos and the cosmos in general. Swim and Tucker write that this worldview is often defined as deterministic materialism, a worldview that emerged in the late 16th century amid intense debates over natural philosophy. It had three tenets: that all things in the universe are composed of tiny particles of matter, that these particles are purely material without any degree of subjectivity, and that these particles move according to fixed mathematical laws. Perhaps the origin of this worldview is to be located in history, perhaps in ancient history, to the agricultural expansion that began around 35,000 years ago and pinnacled in the Neolithic revolution of 10,000 years ago, as Taj writes, when a pivotal change, ultimately important not only for humanity but for the rest of life, as we can see today, was the new conception of the environment formed in the minds of the fledgling farmers and villagers, whereby natural habitats were no longer wild places in which to hunt and gather food and occasionally burn over with ground fires, and rather became land to be cleared for agriculture. And this particular conception, that wild land is something to be replaced, has been a mental fixation for most of the world's population to this day. Perhaps we can look at the traditional biblical texts or sacred texts. I'll use the biblical one just because it's one of the most well-known, but it's not the only one. Lynn White Jr. Argued that to many Christian scholars, the rest of creation exists solely for human benefit. And he concluded by stating that Christianity is the most anthropocentric religion the world has seen. Of course, he was referring to particularly two passages in Genesis 1:28 and 1:30, in which it is said that God blessed them and God said unto them, be fruitful and multiply and replenish the earth and subdue it and have dominion over the fish of the sea and over the fowl of the air and over every living thing that moves upon the earth. And this is particularly focused on two words, kabash and rada, often translated as subdue and have dominion over. Not the only translation, of course, but perhaps the most notable. Or perhaps we can look at the philosophical tradition that we possess, and the most ancient text of the most ancient philosophical tradition that we possess, the text of the Greek philosophical tradition. And we can see that the early philosophers, the pre-Socratic philosophers, were concerned with nature and the definition of nature, or better, the definition of matter. What is the Urstoff, the primitive element of all things, the pre-Socratic asked? What is the unifying principle of reality, what Aristotle defined as the material cause of the universe? Is there a single kind of matter, they asked, which everything is made of? Or are there multiple kinds of matter? Is matter a continuous substance capable of expressing itself in multiple forms? Or is it comprised of a number of discrete, unchanging constituents? This is what led Parmenides to birth the articulation of the ontological pursuits as we conceive of them today, the study of being. And he famously said that everything that is and cannot not be. But by creating this category, he also created the possibility of not being, the possibility of the void. And it is in this void that the atomists, with Democritus being the most famous of them, argue that nature or matter is comprised of discrete, separate, and somewhat etiologically independent units, which he and they called atoms, atoms that float in a void of nothingness. So this apotheosis of the conception of matter, which then slowly created an ethical space to be inhabited. And since it's not possible to hurt or damage nothing, everything that was then located in that void, into that nothingness, then was not capable of being damaged. This was then, this was married with the idea of transcendence, which was introduced by Plato, then taken up by the Neoplatonics and Christianity, and particularly by the Gnostics. And this idea of two distinct worlds, a world of matter and a world of spirit, that are completely separate, that they exist in separate realms, that somewhat don't touch themselves, if not, don't touch each other, if not very superficially. Combined together, these multiple strands, these multiple ideas, led to the birth of modern science, and in particular to the Cartesian view of the world. Descartes famously introduced an epistemological syllogism. He said, well, how do I know that I exist? How do I know that anything exists? Well, I know that I exist, and I think because I think, and therefore I am. So thought exists, I think, therefore I exist, therefore I am. Now, what was originally an epistemological syllogism soon became an ontological syllogism, one that divides all of existence between the res divina, the thing that belongs to God, the res cogitans, the mind, and the res extensa, everything else, matter. And famously, Descartes divided the mind, or assigned the mind only and exclusively to humans, giving birth to human exceptionalism, to mechanicism, and to determinism. And so a frog, because of this particular worldview, stopped being an animal, a being with feelings, fears, desires, choices. And it became nothing more than a clockwork, a piece of machinery, of biological machinery, but still machinery nonetheless, that could be assembled and disassembled at will for any kind of pursuit that was deemed necessary or valuable. That's what allowed Alessandro Volta to explore the power of electricity by doing the most gruesome experiments on frogs. And we can see that in the vivisection experiments that still exist today. Swim and Tucker write that for centuries, scientists have attempted to explain the universe by means of physical laws expressed in mathematical equations. The universe was thought to consist of mechanisms within mechanisms. And modern industrial humans did not seek to commune with nature any longer. They sought to transform the world. Using new technological powers, they would create a better world, one with greater quantities of food, more efficient transportation, and faster communication. Using their new machines, they would eliminate poverty, hunger, and sickness. And perhaps the intentions were, at least at times, that noble. But in reality, the results were far more grim. Francis Bacon, for example, one of the fathers of modern science, emphasized the need for humanity to subdue nature, seen as the ultimate enemy. And he called men, gendered in his work, to, quote, unite forces against the nature of things, to storm and occupy her castle and strongholds, and extend the bounds of the human empire, end of quote. Now, this particular approach, which is contained in the idea of human exceptionalism, humans being separate and superior and somewhat independent from the rest of existence. This led to a worldview well known as anthropocentrism, and in particular to a worldview that René Dubos calls crude anthropocentrism, a worldview that is comprised of a number of tenets that I will not explore in depth here in the presentation, such as legal formalism, patriarchy, the idea of of nature as either as a wilderness or Arcadia, materialism, mechanicism, determinism, hyper-rationality, and so on. And so, what are the consequences? Well, that nature became something to conquer, as Francis Bacon's word. And the result is that we are now acting, Thomas Berry writes, on a geological and biological order of magnitude. We have crossed over into an Earth whose very atmosphere and biosphere are being shaped by human decisions. We live on a planet now where not biology but symbolic consciousness is the determining factor for evolution. Cultural selection has overwhelmed natural selection. That is, the survival of species and entire ecosystems now depends primarily on human activities. We are faced with a challenge that no previous human has ever contemplated. How are we to make decisions that will benefit an entire planet for the next several millennia? Now, this idea of nature as something to conquer can be seen in plenty of numerous television shows. Some of you may remember Men vs. Wild, a TV show with Bear Grylls biting into every possible living animal or recently killed animal. And the idea of man versus wild, first of all, the patriarchal idea of man, gendered in the title, and the versus that really depicts a war between humans and nature. Or a modern version of this are the many alone reality TV shows, the subtitles of which are telling: if the isolation doesn't get you, the grizzlies will. Survive 100 days and win $1 million. You are Norway. Again, these are depicting nature as a hostile space in which humans are to suffer. They live a brutish, nasty life, to use Hobbes, to paraphrase Hobbes. And so everything that we see, an ocean, for example, doesn't have any value in and of itself unless it's conquered, unless it's developed for human pursuits, for human purposes. The consequences are for all to see. The degradation of the soil, death of biodiversity and biodiversity reduction, pollution. We can see the effects in the wildfires that sweep across the planet on a regular basis, more than once or twice a year, or the floods that are covering entire villages over and over again. But the transformation didn't happen exclusively because of these ontological possibilities that I just described. Economic theories of values moved from the physiocrats with Francois Quesnay, the father of economics, to marginal value theory with what Mariana Mazzucato in The Value of Everything describes as a fundamental shift in the economic theory. But most importantly, it was particular legal structures that permitted this transformation. And Nicole Graham adopts a convincing term, lawscape, to describe the intrinsic interdependence between law, property regimes, and environmental ontologies. And given human pervasiveness and technological invasiveness today, every landscape that we see, be it a cityscape or be it a natural park, is the direct result, Graham argues, of a combination of ontological possibilities and legal structures. It is only because we have national parks acts that we see national parks. It's only because of property and development regimes and schemes that we see cities. So everything that we see is a lawscape. So the question is, if everything that surrounds us is nothing that matter, then what are the implications for these lawscapes and law views? If nature is nothing more than matter, what does it mean in legal terms? Well, it means that nature is just a collection of objects. Now, the institutes of the Roman institutes divided the books of private law, or lex civilis, in three parts, so that everything that exists is legally divided into three parts: persone, persons; res, things; and actiones, actions or procedures. Leibniz then further developed this stratification into subjects, objects, and causes of a right. And then William Blackstone incorporated this in the common law in England. And so nature, by not being a subject being all the humans and their constructs, became nothing more than a collection of objects, particularly of objects of another subject's rights, and particularly of objects, nature as an object of someone else's property rights. Now, if nature is an object of someone else's property rights, and if the subject of those property rights has unfettered dominion over the object of those rights, then of course the destruction of an old-growth forest is legally invisible, or at the very least, legally irrelevant. That is what Christopher Stone spoke against. This is what prompted Christopher Stone's momentous question. And Stone's question was located within a growing environmental movement. Ecology had, by the 70s, started to inform both sciences and the humanities. And Justice Douglas' dissenting opinion in Sierra Club and Morton remains to this day one of the most poetic judgments ever written. He writes that inanimate objects are sometimes parties in litigation. A ship has legal personality, a fiction found useful for maritime purposes. The corporation soul, a creature of ecclesiastical law, is an acceptable adversary, and large fortunes ride on its cases. The ordinary corporation is a person for purposes of the adjudicatory processes, whether it represents proprietary, spiritual, aesthetic, or charitable causes. So it should be as respect valleys, alpine meadows, rivers, lakes, estuaries, beaches, ridges, groves of trees, swampland, or even air that feels the destructive pressure of modern technology and modern life. The river, for example, is the living symbol of all the life it sustains or nourishes: fish, aquatic insects, water ouzels, otter, fisher, deer, elk, bear, and all other animals, including man, who are dependent on it or who enjoy it for its sight, its sound, or its life. The river as plaintiff speaks for the ecological unit of life that is part of it. Now, this very poetic judgment remained unheeded for over 20 years, until the time that self-described eco-theologian Thomas Berry and Cormac Cullinan, who is present here, called for an earth jurisprudence. They argue that if Cormac Cullinan describes an earth jurisprudence as a philosophy of law in human governance that is based on the idea that humans are only one part of a wider community of beings, and the welfare of each member of the community is dependent on the welfare of the earth as a whole. And from this perspective, human societies will only be viable and flourish if they regulate themselves as part of this wider earth community. And so in calling for an earth jurisprudence, Cormac argued that in his book Wild Law, that nature, the wilderness, the untouched spaces are not a space of chaos and disorder, but rather are places of ultimate order, ultimate homeostasis. And it is with this in mind that we should be regulating all human legal structures. What does that mean in practice? It means that nature stopped being just cast as an object of another subject's rights and became a subject of and or with inherent and intrinsic rights. There are many terms that have already been introduced: earth jurisprudence, wild law, the idea of nature as a subject of rights, the rights of nature movement. Other terms such as earth law, earth laws, the ecological law or ecological law in governance. All these terms and all these initiatives that follow from these terms are, to my mind, the expression of a broader tendency, a tendency toward a theory and praxis of law known as a jurisprudence that is informed by ecological considerations, an ecological jurisprudence. So ecological jurisprudence is thus not a single construct. It's not a single idea, but it's rather a spectrum of theoretical possibilities. All those theories and practices of law that are informed by ecological considerations and articulate themselves in opposition to the crude anthropocentric worldview that I've described before, fall, I propose, within the confines of this emerging ecological jurisprudence. And the spectrum ranges from the slightly enlightened anthropocentrism of particularly early environmental law to the much more radical ecocentrism of some authors. In practice, this has seen, obviously, the emergence of environmental law, which is kind of a protean response, somewhat still very anthropocentric, to ecological concerns, to animal rights and species rights, to the rights of nature as a whole, to the proposal of ecocide, to the introduction of an ecological civilization, particularly in Asia, to many soft law documents. We're not going to be able to go through the history of international and national environmental law, but we can see how the discourse in international law has shifted from early days in which humans operated at the center of everything to the introduction of the UN Harmony with Nature program a decade ago. The idea that nature is a subject, it has an identity in and of itself. Of particular interest are the many instances of rights of nature. What David Boyd, former UN rapporteur on the environment and human rights, described as the fastest growing legal movement of the 21st century. And we can see that the eco-jurisprudence tracker, which was introduced 3 years ago now, has seen a growth of initiatives that is almost exponential in nature. In 2008, at the time of the Ecuadorian Constitution, perhaps the most momentous document that introduced rights of nature in the legal consciousness, the collective legal consciousness, by recognizing the Pachamama, the divine feminine, one of the key principles in Andean cosmology, as a legal subject, as a subject of rights in 3 constitutional provisions. So there were maybe 2 or 3 legal initiatives that had been passed at that time, and only one successful one, the Ecuadorian Constitution. That saw a growth of initiatives to almost 430 initiatives across 42 countries, plus the international level in 2022, when the Eco-Jurisprudence Tracker was created, to more than 540 at present. So we can see an incredible growth of initiatives. And we can see trends there. We can see that US ordinances focused on citizen-led initiatives. Ordinances are a relatively unique legal instrument of the US. We can see a constitutional approach, the one taken by Ecuador, which led to a number of cases, from the first successful case, the Vilcabamba River case in 2011, to many more recent ones, famously the Los Cedros case in 2021, which recognized the rights of nature as trumping the development and the mining rights granted to an international, a transnational corporation. We can see the approach of Bolivia, which shifted away from the language of rights to focus instead on the language of responsibilities. We can see that the introduction of specific instances of nature, the Teurewera forest, the Te Awatupua Wanganui River, and recently the Taranaki Mountain, which I didn't put on the slides, apologies. We can see the judicial activism of India, which was then stayed by the Supreme Court of India, or the successful judicial activism of Colombia. We can see the soft approach that Australia used with the Yarra River Protection Act, which recognized the Yarra River, the river that flows through Melbourne, as a river, as an integrated living entity, not necessarily a legal subject, but close enough. We can see the introduction of rights of nature in Europe through the Mar Menor legislation in Spain, which recognized the salt lagoon of Mar Menor as a legal subject. We can see that how US tribal law has now become the protector of rights of nature discourse in the US. There are many more cases, and I refer you back, if you want to the eco-jurisprudence tracker for seeing many of that. Term ecocide, on the other hand, which was introduced in the 70s, was then proposed in 2010 by Scottish lawyer Polly Higgins as an amendment to the Rome Statute, arguing that it should be seen as an international crime for which offenders could be prosecuted at an international level. We have seen that the China first and then many other Asian countries argue that many lawyers, in the words of Wang Yuqing, have been charged with supporting one of the most fundamental shifts, societal shifts in human history. He argued that humans have progressed through primitive civilization, agricultural civilization, industrial civilization, the latter now at the end of a 300-year run of unsustainability, and that we need to shift toward an ecological civilization if we are to survive as a species. We can see a lot of soft law in civil society organizations, from the Universal Declaration of the Rights of Mother Earth to the very momentous encyclical that the now recently passed Pope penned in 2015, the Laudato Si. We can see many organizations that have emerged. We can see activism. All of this fall within, I believe, the what I call the trend toward an ecological civilization. But this obviously is not without issues, without questions. What do we mean by rights when we speak of rights of nature? Do we speak of rights of nature, rights as intrinsic to nature itself? Or do we speak of rights attributed to nature by human desire or human constructs? Some argue that rights are used here as strategic tools to bring the awareness of environmental litigation through the lens of the court process. And then the courts are tasked with the idea of balancing rights between the rights of development and the rights of nature. Some argue that the idea of bringing rights forward bring forth what is known as the Herfeldian correlative. William Herfeld was a legal theorist of the early 20th century who argued that there are legal correlatives. There are legal principles that have inherent correlatives that balance them out. And so rights always have a correlative duty. In order for someone to have a right, someone else have a duty to permit, respect, or empower those rights to exist. And then there are privileges, no rights, and so on. And so by bringing forth nature's rights, we also focusing on human responsibilities, on human duties. But what do we mean also by nature? Is an Aston Martin natural? Is it more natural than a fruit salad? Some may intuitively say yes, but why? The individual components of these two items do not exist without human intervention, be it the metals that are fused together or the type of strawberries and fruits that we eat today, which are the result of genetic manipulation by humans for over millennia, centuries. The strawberries were introduced by Benedictine monks, for example. But what about the combining them? They don't exist without human combination. So what does it make a fruit salad more natural than a car? What about cane toads? They're an invasive species here in Australia that have replaced pretty much all frog species by killing them and creating in devastation, biological devastation as an invasive species. They have replaced the pre-existing species that inhabited the same niche. And that is seen often as a pest. But what about the dingo? An iconic Australian animal that was introduced around 5,000 years ago and then quickly replaced the marsupial predators that predated it. Why is the dingo less invasive than a cane toad in Australia? And famously, Peter Singer argues that the ethical respect that we owe to animals is due to their sentience, their capacity to feel pain and to feel something. And he provocatively placed sentience between a prawn or a shrimp and a mussel. But why? Isn't that as arbitrary as Descartes' attribution of the mind only to humans? We now know through a lot of research that plants display, like through the work of Monica Gagliano, for example, that plants display the same degree of consciousness, or the same markers, not degree, sorry, the same markers of consciousness that animals display. So should we speak of as freely as rights of shrimps as we speak of rights of carrots? What if we go further? What about rocks and rivers? White Jr. asks, do people have ethical obligations toward rocks, to almost all Americans, still saturated with ideas historically dominant in Christianity? The question makes no sense at all. But the question does make a lot of sense to many traditions in the world. What about rivers? The idea that rivers are the veins of the earth or spirits themselves, which may sound quite obscure, is no longer obscure with the recognition of the rights of the Wanganui or the Atrato or the Vilcabamba, for example. What about personhood? Should we speak of personhood as the classical distinction between natural persons, humans, and artificial person, their constructs, that is, corporations, states, and associations? Or should we speak of a new category of personhood, an idea of an environmental personhood, a sui generis category of personhood? And what does that mean? Does that mean that an environmental person is to be seen as liable for damages that it causes? Is a river that floods liable for damages, or is a river just fulfilling its own existence by flooding? What about representation? Who speaks for nature? Another question, this question has been answered in many ways, and perhaps the most intriguing one is the one offered in New Zealand, where the representative of the Wanganui iwi, there are two representatives that speak for the river, the Te Awa Tupua, one appointed by the Crown and one by the iwi, the traditional community that identifies with the river. And to them, they're not speaking for the river, they are speaking with the river. So all of these questions can be placed in a matrix, and we can look at ways of changing behavior through positive and negative, direct or indirect incentives. And in this way, the ecological civilization is a positive, a creative way of actively changing the world, whereas taxation, like carbon taxes, are a negative, indirect disincentive to damage the planet. These questions and the questions that I've just posed before are far from daunting. They actually invite a plethora of interdisciplinary reflections. And so the trend toward an ecological jurisprudence fulfill three major purposes. Firstly, it pushes us beyond the Anthropocene. Secondly, it asks us to ask questions of law itself, of the nature of law itself. And thirdly, it creates perhaps the first truly intercultural platform in which legal systems can discuss as equal among themselves. So, as I said, these questions have invited a plethora of reflections. Jane Bennett, for example, in her quest for a political ecology of things, sets herself the task of challenging the binary opposition of life and matter, human and animal, organic and inorganic, and of developing a way of thinking about political matters that can better account for the contribution of non-human actors. Bruno Latour asserts that ideas of nature are historically situated constructions of human consciousness. And in rejecting the basic distinction between nature and culture, Latour claims that the development of modern society has rested on a collective self-delusion, and that the process of setting the natural world against culture as either a chaotic force that needs to be controlled or a mother nature in harmonious balance is unique to the Western philosophical tradition. And on the contrary, he posits a world of highly complex relations between humans and non-humans, between things and animals, in which the latter are granted the same amount of agency as humans. But more than that, what does that mean for legal theory? So legal theory traditionally is distinguished between natural law theory and positivism, or legal positivism. Natural law theory asserts that there are some universal moral norms that inform all human behavior, and that any law that deviates or contrasts with universal moral truths is either not law or is unlawful. Legal positivism, on the other hand, argues that laws are arbitrarily construed by humans for the benefits of humans, and whatever benefits humans believe them to give. So the question could be as to whether these various aspects, these various expressions of an ecological jurisprudence are a novel form of natural law theory. But they're not in the modern sense of natural law. Thomas Aquinas wrote of the lex naturalis moralis, the natural moral law, whereas we're speaking of something that is physical, is tangible, that there are patterns of existence that are not necessarily exclusively moral in nature. Of course, some have argued that these ecological principles act as a modern Grundnorm, as a modern boundary of law. Maria Chiara Tallachini says that, similar to, in a way, or paraphrasing Hart in a way, says that this the ecological principles are the necessary prerequisite for any legal system to exist or to continue to exist over time. But natural law theory is too informed by rationality and anthropocentric assumptions for ecological jurisprudence to be really called a modern natural law theory. And so I think ecological jurisprudence moves beyond the natural and the positive. And it asks questions about normativity itself. Is nature normative? In other words, does nature create the conditions for norms and rules? Certainly it is, as Latour says, as an actant, because it acts upon the world. But maybe it can be also conceived of as an active participant in a normative dialogue. This is what Vargas Rocancio calls the stories of vegetal ontologies in the Amazons, saying that the plants give rise to indigenous law in the Amazons, according to the words of plant knowledge holders, who shared with him the idea that from these plants, de aquí viene el derecho indígena. From here comes indigenous laws. And also, this leads us to the third function, the third aspect of an ecological jurisprudence. Because if the trend of the movement toward an ecological jurisprudence represents the first grand narrative of law after Kelsen for over 100 years, it is also the first place that creates an intercultural platform. It's the first truly intercultural and internormative dialogue, because Indigenous peoples have occupied a crucial and central space to the emergence of rights of nature discourse from the beginning. The Pachakutik movement has been instrumental to the Ecuadorian Constitution of 2008. Thomas Berry writes, acknowledged that Indigenous worldviews predate his own ecocentric or biocentric critique. He said that one of the most striking things about Indigenous peoples is that traditionally they live in conscious awareness of the stars in the heavens, the topography of the region, the dawn and sunset, the phases of the moon, and the seasonal sequence. They live in a world of subjects, that is a world of inner expression shared by every mode of being, not a world of objects. Nothing is without its identity, its dignity, its inner spontaneity. Everything has its sacred dimension, which must not be violated. Abram writes that many authors, less poetically, have come to recognize that long-established Indigenous cultures often display a remarkable solidarity with the lands that they inhabit, as well as a basic respect or even reverence for the other species that inhabit those lands. Such cultures, much smaller in scale and far less centralized than modern Western civilization, seem to have maintained a relatively homeostatic or equilibrial relation with their local ecologies for vast periods of time, deriving the necessary sustenance from the land without seriously disrupting the ability of the earth to replenish itself. And Cormac also writes that it appears that certain cultures did manage to evolve laws and other means of regulating human conduct that enabled them to live successfully over long periods of time as part of a wider community of living and non-living beings, succeeding in avoiding degrading their environments as we have. To me, they suggest that they probably know things that we don't, and which would be helpful for all to know. So if the questions that I posed before have been answered very successfully by many Indigenous cultures, and Swim and Tucker write that every place we went, we humans, we became that place. That is the brilliant power provided by symbolic consciousness. With their cultural inventions, humans could adapt to new environments much more quickly than would be the case if they had to rely solely upon genetic changes. That's why the humans who decided to follow the reindeer rapidly became the reindeer people. They walked the same pathways as the reindeer. They ate some of the same foods. At night, in their feasts and their dancing, they celebrated the thrill of being the reindeer people. Other humans aligned themselves with the whales and became the whale people. Some identified with the birds and began wearing feathers and greeting each dawn with song. The highest fulfillment became the act of joining with the birds' celebration. The early humans did not just journey through Earth's worlds. The spirits of each world captivated their imagination as they revisioned their lives in terms of that place. They absorbed every color and sound into their life and soul. And this is why, for example, for the Bunun people of central Taiwan, there is no word for nature. Rather, they use two words combined to describe what the Western tradition calls nature. Asang, the worldview, the way of being in the world, and Taki, the practical way of being in the world, which literally means home, because nature is the place that we inhabit, and excrement, poo, because we generally pollute in the place that we live. We generally go to the toilet in our own place. And so we have a responsibility toward that place. When I asked Uncle Dutch Kennedy from the Sandon Point Tent Embassy, what does it mean to be an Aboriginal person? He said, this is my nature. And when I say this, he added, I speak of my inner nature. And people think that I'm speaking of my inner nature, my inner self. It is who I am. And it's true. But my nature is also the stories that I know that tell me that these birds come here at this time of the year, that these flowers blossom right now, and therefore these berries can be eaten, and therefore this fish is breeding and should not be caught. And so the dialogue between my inner nature and my outer nature, which is culturally construed, is what makes me an Aboriginal person. This is captured in the words "E Hawaii au." I am Hawaii. I am of this land, and this land. I eat of this land, and this land eats of me. And this is why, for the people of the northwestern Amazonian basin, the rivers are not just means of transport or sources of water and food. They are the very veins of the earth, the space through which the ancestors travel endlessly, recreating the world. This is also seen in the Aboriginal worldview, in which each rock, each waterfall, each tree is not just a memory of the spiritual world, but is an expression of the spiritual world itself. And so all these ways of seeing the world remind us that there are other ways of seeing, other ways of being in the world. But these worldviews do not exist in a parallel or an equitable place of power. And those who hold power over others determine which of those worldviews can or should be accepted or not. And so the risk of environmental colonialism, the risk of imposing a particular worldview, an environmental persona in a Foucauldian sense, is always ever present. And we should be reminded against that. And in light of the beautiful Earthrise picture that was captured by the Apollo mission, I would like to read this passage by Wade Davis, who reminds us that the beauty, preciousness, and importance of the diverse ethnospheres and nomospheres that we inhabit. He writes that one of the intense pleasures of travel is that the opportunity to live amongst peoples who have not forgotten the old ways, who still feel their past in the wind, touch it in stones polished by rain, taste it in the bitter leaves of plants. Just to know that in the Amazon, jaguar shamans still journey beyond the Milky Way, that myths of the Inuit elders still resonate with meaning, that the Buddhists in Tibet still pursue the breath of the Dharma, is to remember the central revelation of anthropology, the idea that the social world in which we live does not exist in some absolute sense, but rather is simply one model of reality, the consequence of one set of intellectual and spiritual choices that our particular cultural lineage made, however successfully, many generations ago. All these people teach us that there are other options, other possibilities, other ways of thinking and interacting with the earth. And this is an idea that can only fill us with hope. And I know that some of, at least one person here in the audience today, is showing how these different ways of being, seeing, and thinking are not the purview just of indigenous cultures, but they exist in all cultures still. They might be forgotten, they might be excluded, they might be silenced, but there are memories of this in the way we see glaciers in Europe, or the way some see rivers in Europe, for example. And so perhaps I'd like to conclude with a final anecdote of something that Cormac shared with me many, many years ago. Cormac, please correct me if I am completely off the mark in recounting the anecdote. But for artistic purposes, let's say that even if it is not absolutely correct, let's accept it for the beauty that it carries, hopefully. And then Cormac was working with some indigenous elder in South Africa and was trying to negotiate some common ground between the community that he was working with and the entities, the multinational corporations that they were trying to negotiate with. And this elder, looking at Cormac, somewhat puzzled, said, "But you're constantly speaking of common ground, as if it is something esoterical, distant, ephemeral almost. But the common ground we always seek is always here, is always already here. It's always under our feet." So thank you so much for listening, and I hope this presentation was a way of capturing the stories that I much more in depth explored in the text. I put here the text and the link to the text. I know that many of you already know it. The text is open access, so I made sure that everybody can download and access the text, at least in a digital form, for free, via the link provided below. So thank you very much, and I look forward to the discussion.
Thank you very much indeed, Alex. That was great. So one of the things that I'm interested in is that, I was stunned by how much work went into your book and how much effort must have taken to do that. And so I was just wondering, what if you could tell us a little bit of the sort of backstory, what made you decide to write it, and what impelled you to put the amount of time and effort that it requires to write a book like that, and over a very extended period of time.
Well, yes, Cormac, thank you. And as you know, you are kind of one of the reasons that the book came into being. So Cormac and I, for the benefit of everyone listening, met virtually in 2010 when I was organizing the second Australian Conference on Wild Law and Earth Jurisprudence. I had discovered the emergence of Earth jurisprudence through the work of Cormac Wild Law in 2009. And to me, it struck a chord. I even described it as being what I call ecological jurisprudence being to law what theoretical physics is to physics. It was to me the theoretical boundary of what law could pursue. It was the idea of asking the most difficult questions about jurisprudence, normativity, the nature of law itself. And so with that in mind, I started exploring and really thinking thoroughly about what the emergence of an ecological jurisprudence meant. And I discovered that there were many contrasting opinions, contrasting ideas, opposing, almost conflictual attempts to define an earth jurisprudence, wild law, earth law, etc. And I felt that there was no necessity to create small kingdoms. I thought that it was more necessary to create a network, to paint a picture of the network, not just the practical and activist network that existed. Craig Kaufman and Pamela Martin did a beautiful work in mapping the networks that underpin the rights of nature movement. I wanted to map the theoretical network that underpinned it all. What were the connections between the ideas and the worldviews that linked the Pachakutik movement in Ecuador and the activism at the European Union level, for example? What is it in the Western philosophical tradition that could match the worldview of the Bunun in Taiwan, for example? And so my interest was to bring together my expertise in legal anthropology and what I had learned in the course of 10 years working first supporting the drafting of the UN Declaration on the Rights of Indigenous People, and then doing my PhD at the University of Wollongong on legal pluralism and native title. So different worldviews and different legal orders that were operating at an equitable philosophical level. So that was the premise. And then I'm not a fast writer in that when I have an idea, I don't write straight away. I take a long time, meaning years, to think through that idea. And I write quite in opposition to the academic model that wants us to write quickly and fast today. And so I gave myself, effectively 15 years before the book was written. But if we count the 15 years plus the 10 years prior, it's a quarter of a century that I poured into this book. And I secluded myself for a few months where I really poured through all the texts that I could find of Western legal theory, of anything that was written on the topic. I tried to be a human ChatGPT in a way and do a meta-analysis of everything that had been written and see it and read it through the lens of my expertise and my dialogue with others, such as yourself, obviously, but many of the people who are here today, and many people who are not here today that we know and that have been amazing and instrumental in the work.
Thanks. That's very interesting. And I must say, I do take my hat off to you for sticking it for so long and for the incredible breadth and depth of your scholarship. And one of the things that struck me when I wrote it was that when I read it, was I don't think that many legal scholars in the world could have written a book like that, because you bring to it a particular understanding of legal pluralism and indigenous knowledge from many different cultures, which really, I think, makes it a much deeper and richer work than would otherwise be the case if somebody was writing about the subject from within a single legal framework or understanding. And I'm just curious about, we sit with a situation where many indigenous worldviews are already so different to the kind of thinking, the anthropocentric thinking, which is prevalent in the dominant religions and which informs their legal systems. And even as you know, the word rights is not necessarily used by many indigenous peoples. So I was wondering, it's an uneasy relationship, if I can put it that way, between these two worldviews and hence with their legal systems. And do you see these? Do you see ecological jurisprudence playing any role in either bridging those worldviews or perhaps infusing the dominant cultures with some of the understandings that they have attempted to obliterate in the indigenous cultures? Because some people would argue that these two worldviews are simply incompatible and that you can't really link them or bridge them in any way. So I was just interested in your thoughts about that.
I think that's a great question. And I think it's important to, first of all, to note that there are not two worldviews, but that there are many worldviews. And so the tension is not between two worldviews that are incompatible. The tension, I believe, is between a dominant and a non-dominant form of power. There's a hegemonic attempt by a dominant network, which is primarily informed by the Western legal tradition, although not exclusively, and the non-dominant legal systems that have been dominated through the process of colonialism over the past 5 centuries, 6 centuries, perhaps longer than that, but very explicitly over the last 4 to 5 centuries. So the tension is not between different ways of seeing the world, but different ways of operating power upon the world. And the power that is operated by the dominant worldview, by the dominant worldviews, is capable of silencing those other worldviews. But it doesn't mean that by casting it as an opposition between two worldviews, it's almost like casting judgment as one being good and the other one being evil. It's much more complex and much more nuanced than that. What do I mean by that? I learned when I was in Hawaii that the representation of gods in Hawaii. So this sounds like a long, convoluted answer, but it'll get to a point. So bear with me for a second. That in Hawaii, the gods are not seen as the controllers of the realms that they represent. So Pele is not the goddess that controls the volcanoes and fire. She is the volcanoes and fire. Kanaloa is not the god that controls the fresh water. Kanaloa is not the god that controls the salt water, the oceans. Nkane, his brother, is not the god that controls the fresh water. They are fresh water and salt water. When you swim in the ocean, you are swimming in Kanaloa itself. And then the idea of the relationships that they have, Kane and Kanaloa being brothers, is a way for us to intuitively understand the complex ecological relationship between fresh water that falls and salt water, and the cycle, the hydrological cycle that is described by ecology today. Now, this is not dissimilar to the idea of Pontus and Uranos, the ocean, the salt water itself, that the primordial gods, that the Greeks call as the primordial god, and Uranos, the sky itself. Two brothers, once again. And the modern version being obviously Zeus and Poseidon. And I remember talking about this, saying, well, clearly, Zeus and Poseidon were, for the ancient Greeks, the sea and the sky. They weren't the god controlling the sky with a lightning in his hand or a trident in his hand, controlling the sea. But they were the sea and the sky. And I remember this Torres Strait Islander colleague of mine saying, no, you're wrong. Poseidon wasn't the sea. Poseidon is the sea. The sea hasn't disappeared. The sky hasn't disappeared. So Poseidon and Zeus still exist. And so within the dominant traditions that have led to that crude anthropocentric worldview, there are still many trends and threads that are still as deeply ecologically intertwined with the rest of existence as they always have been. And I know that others here can speak to similar ideas in relation to the myths of the mountains, the farness of the Eastern Alps from which my genetic ancestors come from, for example. And so the tension then is not between different worldviews, is between the dominant use and usurpation of power and those who don't. Now, what we can see as two distinct ways of approaching the universe is one that sees the universe as just being there for my benefit. There's an individual hedonistic approach in which I do what I need for myself. Maybe I can extend it to my family and my group, but generally it's for myself, ultimately. There's an egoistic, selfish, and somewhat childish approach to life. And the other one is a relational approach to life. And in recovering or restoring the kinship worldview, the authors write that there are three things: relationality, reciprocity, and responsibility that form the basis of a communal indigenous worldview. Indigenous worldviews vary dramatically from hunting-gathering semi-nomadic groups to very settled agricultural societies. So it's not possible to particularly speak of one indigenous worldview, but it is possible to speak of a relational worldview that is more common among indigenous people, and it's still present in a non-dominant form in the Western philosophical tradition. And it is that relationality in which everything is related, and when everything is related, we do have responsibility toward which we are related, and we have reciprocity or reciprocal obligations toward those who grant and gift us with something in our relations. So I would say that what an ecological jurisprudence does is opening up the space of the dominant Western-derived legal tradition to creating a space for an intercultural and internormative dialogue that then allows us to accept that there are other ways of being and regulating ourselves in relation to the universe. And maybe in understanding that, we also remember and are reminded of less selfish, less childish ways of relating to the cosmos.
That's great. Thanks, Alex. I think that's very helpful. And certainly I think that for people who trained in, for want of a better term, let's call it Western jurisprudence, if one sees everything other than humans and corporations as object, then one doesn't even get into the language of relatedness or relationships, because you don't have to worry about your relationship with an object. And I think one of the most important things for me about this work is that it reanimates the world and shifts the discussion from how we use the rest of the world to how we relate to other beings who are subjects. And whether you call it legal personhood or not, as soon as they become subjects, one's into the language of relatedness and relationality, which I think is so important, and as you have brought out very strongly, is so characteristic of indigenous perspectives. But we at the moment living through a tough time in human history. Where everyone looks, the news tends to be depressing, and it certainly looks like the sort of dominator way of thinking is on the rise in many places in the world. So there may be people who would argue, well, this is all lovely philosophy, but is it really going to help in the face of what we face in the 21st century, what humanity faces in the 21st century? So I suppose, although our discussion has been very philosophical and importantly so, I'd just be interested in your views as to whether you think that the kind of work that you've set out and explained in your book is of relevance to the challenges humanity is facing in the 21st century, and if it's helpful in any way.
So that's a great question, and two parts to this answer. But before I get there, I just wanted to acknowledge the comments in the chat. Really good comments as well. Thank you. And I wasn't really familiar with the anthropologist being quoted, and thank you for doing that, because I will follow that up definitely. And I think that also connects to the answer that part of the answer that I would like to give. The first one is more pragmatic, if you want to, more neutral, or attempts to be more neutral. Rights of nature, ecocide, the ecological civilization are all instruments in an attempt to create a normative world in which we live according to norms and laws that permit an ecological homeostasis rather than the degradation of the world that we see today. And I'd like to share a few numbers later as to that. And yes, actually, just in answer to the question, yes, I've actually have used Michel Serres in the book itself. Great book, The Natural Contract. So if I can share a few numbers just to talk about the ecological predicament that we live in, the population growth of the planet, just to give a number. When I wrote the book in 2022, there were 7.9 billion people on the planet. When I updated the book in 2024 for the final edition, there were 8.29 billion people on the planet. Almost 400 million people more on the planet in 2 years. That's more than the population of the United States in 2 years. Mm-hmm. So against the cries for a population decline that people like Elon Musk very superficially speak of, we still have a population growth for the foreseeable future. In fact, actually, the UN is foreseeing a population growth of 1 to 3 billion people by 2050. Now, just to put that in context, let's say 2 billion people over the next 15 to 20 years. Now, that means that these people will need to be housed, will need to be fed, will need to be placed somewhere. So let's imagine a city of 1 million people, a city like Turin, where I was born and raised. It would mean to accommodate and house 2 billion people over the next 25 years. It would mean to build a city like Turin, a 1 million people city, every 4 days. That's the magnitude of the scale. The consumptions have arose similarly. The overshoot day, the day at which we go over the amount of resources that the planet is likely able to replenish in a year, moved from the 31st of December in the early 1980s into 2022 to the 21st of August. And then from 2022 to 2024, in 2 years, it moved from the 21st of August to the 1st of August, almost like a 10% growth in 2 years of consumption. That means consuming more things, more resources. That means that there are more, now, according to a recent study, there are more things that humans have built, roads, cars, clothes, things. The mass of things that have been built is more than the mass of all life on the planet, including all trees. The plastics, which 95% of which have been built or made over the last 15 years, the mass of plastics on the planet exceeds the mass of all animal life on the planet. There's more plastic out there in the world than there is animal life. And obviously the consequences are direct, like plastics, nanoplastics and microplastic affect our endocrine system. all this pollution is rapidly reducing biodiversity. We have the biodiversity. So the scientists say that an extinction event is considered when we lose 80% of the biodiversity of the Earth within a very short period of time. And we have 5 great extinction events that have been sort of recorded throughout the billions of years of evolution of Earth life. We have lost, in 2022, the Living Planet report said that we had lost something like 69% of biodiversity. In 2024, the new Living Planet report, which was released before the Biodiversity COP, said that we have lost 73%, an increase of 4% of biodiversity loss. So the numbers are dire. However, that doesn't mean that we need to have a dire response. And so while these are ways of responding in a more gentle way than a more authoritarian fashion, because it's easy to see how the speed of this can easily lead to a very authoritarian response, what people call environmental fascism. There's the suspension of the rule of law, the state of exception because of environmental crisis or environmental fears. However, fear, the language of crisis, the language of collapse are all words and languages that are still part of the crude anthropocentric worldview. There's nothing that says that we have to live in a world of fear. Even in the face of death, we can choose to die in many different ways. We can choose to deal with threats in different ways. We don't have to choose to be responsive or reactive to Elon Musk's, as someone pointed out in the chat, pronatalism, the idea of increasing the white population and not the non-dark skinned population of the world, the eugenics mindset that underpins that particular worldview. We don't have to abide by the tariff world that people like Trump and his associates believe in. We can choose to live differently. We can choose to see the world differently. And I think that's the gift of the ecological jurisprudence. It's like Alan Watts says, we don't have to try and change the world. We can just change the way we live in the world individually. And like in the famous book, The Selfish Gene, Richard Dawkins writes of these 2 particular ways of being in relation to each other, the hawks and the doves. The hawks are selfish and look only after their own self-interest. And the doves are the ones actually who connect to others. And when there are too many doves, the hawks really they expand, because selfish behavior in a world that is non-selfish becomes exploitative, and in the short term they gain a lot of advantages. But when there are too many hawks, it is the doves that succeed, because the cooperative behavior is far more successful over the long term rather than over the short term. So an ecological jurisprudence reminds us that cooperation trumps competition every single time in nature. And so we don't have to engage necessarily, other than in the most basic way in which we have to, with the normative worlds that are imagined by some dominant powers. We can create alternatives. We can just not like Einstein said, we're not going to enact change by doing the same thing that caused the problem in the first place. We can enact change by living together differently. And I think the networks that are emerging, the number of people who are present here, are suggesting exactly that.
That's great. Alex, do you want to answer some of the questions in the chat?
Yes, I can. I see a couple.
Yes. Do you want me to read them out, or you just read them out and answer it?
I can read them quickly. I can see that, and I think everybody can read them. Peter is asking why I think Michel Serres does not surface much in ecological philosophy. I'm not sure. I see him discussed quite extensively in the networks that I engage with. The natural contract was a prefigurative text over 35 years ago. Perhaps he is not as noticeable as some of the more recent authors, but I'd say he's quite, like, in the work that I do, I've seen Michel Serres being used quite extensively. Stephen is asking, but that is not to say that it's not, it shouldn't or couldn't be discussed more. Stephen is asking about the rule of law and what ecological jurisprudence have to say about the rule of law. Well, the rule of law is the idea that introduced first by Aristotle in the first place, that the best way of ruling is through the rule of law, not through the rule of one, the rule of the many, or the rule of the few. Of the various possible ways of ruling, Aristotle said that there are 3 positive and 3 negative ways of ruling. The rule by one, the positive one being the monarchy, in which the ruler acts on behalf of, for the good of all, and the negative of that being tyranny, where the single ruler rule just for the benefit of themselves. The rule of the few, oligarchy, the positive versus, aristocracy, the positive versus oligarchy, the negative. And the rule of many, or all, the polity as the positive versus democracy as the negative, the way in which the masses can be manipulated by demagogues. But of all these ways of ruling, Aristotle said there's one that trumps them all, and it's the rule of law, where we are ruled not by humans, man in his gendered writing, but rather by laws themselves. So no one, the outcome of that, I see actually articulated in the common law, no one is above or beyond the law, not even the monarch in constitutional monarchies. And so the idea that law is the way in which we conduct our relationships with each other and among each other. And what ecological jurisprudence does is that it says that the laws according to which we have to be ruled have to take into account ecological considerations. What Cormac, I think you called it the great jurisprudence, the patterns of normativity that are embedded in the modern human world itself. And so ecological jurisprudence is extending the bounds or the boundaries of the rule of law beyond the human into the modern human. And it's intertwining the rules that humans articulate to regulate the collective behavior in a normative way, together with the patterns of behavior and movements and natural cycles that are outside. And they, in other words, the extension of the rule of law, so this is a bit of a tangent, but the extension of the rule of law beyond the bounds of the human is inviting us to rethink how we interact with the cycles of the universe. And in the words of Rune Rasmussen in Denmark, it's inviting us to redevelop our animism literacy, our capacity to think of the world as animate and to relate to this animate world in ways that respect the cycles of the world itself, the cycle of the moon, the many cycles of the sun, the cycle of the day or the cycle of the seasons, the astronomical season, the cycle of the ecological seasons, the cycle of the plants, the cycles of the water, and so on and so forth. So hopefully that was a way of answering that really good question. Thank you, Stéphane, for the suggestion of Edgar Morin's work. Definitely something to know. And I'm actually making a note there. Yeah.
Perhaps I could just add to your point about the rule of law. I mean, one of the things that I found, I do believe that this work strengthens the rule of law. But you know, in apartheid South Africa, there was a rule of law. The trouble was that the law was bad, and so it was applied. So the rule of law is also dependent on the quality of the law that is ruling. And I think one of the important things about this work is it draws attention to the fact that there are some pre-existing rules or principles that order the universe that aren't negotiable, that we have to adapt ourselves to this earth, and we can't just impose whatever laws we like. So in that sense, although I would see it as strengthening the idea that humans are are bound and must follow laws, it also addresses the quality of the laws by drawing attention to the fact that, for want of a better term, the laws of nature must be part of the ruling laws. You can pretend to ignore what I call the great jurisprudence, or the fundamental principles of the universe, but sooner or later it will come and bite you, because that's a reality that you can't negotiate away, even if you've got a majority a democratic majority in your country. But Alex, I see there's another question.
Sorry, Cormac, before we get to Matthias' question, which is a really good one thing also to add is that the principles that regulate the universe are not self-evident principles. That's an important point. It's not that we just observe them and they actually are self-evident through observation alone. They are construed culturally. And this is an important point, in that the different ways, the different legal orders that we are speaking of have construed different ways of understanding those principles, that those fundamental principles of the universe. So the suggested, Cormac and I had this, I'm just sharing this with the others, Cormac and I had this discussion before, in that there's no suggestion by Cormac or by Sam that science is the only way to reveal the principles, the fundamental principles of the universe. Each culture, each location, each country will have different ways of articulating those principles. And it's only a dialogue between these two. And I agree actually with Stefan, epistemology is fundamental to this discussion. It's only a dialogue between different different normospheres located in different parts of the planet, that then an equal dialogue between them, that a broader understanding of those principles can be constantly negotiated. And this dialogue could be between humans, but also between humans and more than humans. I think it goes beyond that. I think.
Yes,
thank you also.
The interesting comments in the chat about that, but I think you're right, and we were talking earlier about legal pluralism, and I think it inevitably leads to the fact that there is a multiplicity of ecological jurisprudences or earth jurisprudences, in the sense that they may be motivated by the same broad principles, but they are culturally specific and also adapted to the particular environment in which that culture exists, so that the plurality is inherent. And I think is to be embraced. If we look at the universe, we can see that diversity is one of the principles that's clearly evident everywhere in the universe, biological diversity, for example. So I think that this kind of diversity is to be welcomed, but also with the recognition of the fact that because we are all earthlings and are responding to the same earth, there are these commonalities which run through them all. But let me stop there.
And perhaps before I go to Matthias' question, I also wanted to add that the reason I chose the term ecological jurisprudence is that the term was first discussed in 2012. Cormac and I discussed it over the phone, because I was kind of sort of hesitant to limit the idea of, you know, this quantum idea of law to the Earth alone, because the Earth exists in the form it does because of the asteroid belt, because of Jupiter and the gravitational pull of Jupiter. So there are effectively solar systems and galactic principles and forces that allow the Earth to exist in the form that it does. But I thought that calling it galactic jurisprudence would have been a little bit too much. And so I proposed the term ecological jurisprudence instead. And then obviously after that, I actually extended it beyond to the way that I've described. Thank you, Peter, for the suggestions, or the expanded suggestion or reflection on Sarah, which I agree with. To go back to Matthias' question, and then I'll go to the others, is that Matthias is asking whether he writes, quote, rights of nature are also often interpreted as empowering nature and ecosystems against economic interests. How would you see the tension between these two interpretations? I think there are many ways in which rights of nature have been interpreted. There is somewhat an exclusionary interpretation that has been proposed by some advocates of rights of nature. There is a more nuanced and pluralistic interpretation proposed by others. I don't think that rights of nature have been proposed in a single uniform way. There are very different epistemological approaches to the articulation of rights of nature, and that's very visible in the context in which that happens. The Marmenor legislation has a completely ontological, different ontological basis than the Te Awa Tupua legislation in New Zealand, radically so. And so rights of nature, again, creates a platform for that diversity to occur. And that, but I agree with you, Matthias, that tension is something to be very aware of, in that it's important not to think that rights of nature can be articulated according to one way of conceiving rights, be it in the civil law tradition or the common law tradition, which differ as well. And so I think the idea of rights of nature is pragmatic. It's a way of responding to certain needs by using the language that already exists. James Thornton, the founder of Planet Earth, said that whether we like it or not, law is the current language of international institutions, and not being able to speak within or with the grammar of law means not to be able to speak to those institutions. And so rights of nature as a way of responding to those institutions with the same language they speak. But that language, like language in general, can convey quite distinct and contradictory meanings. And so I think actually your point is absolutely correct, Matthias, and something to be very aware and cognizant of. Pranav speaks of the risk of the techno-fixes effectively. He says, can ecological jurisprudence help repair nature and not cause further destruction of nature by AI and renewables? And I agree in that there's a tendency to think that we can fix the ecological problems by increasing the technological outputs that we have today. AI will fix it. Renewables will fix it. Electric cars will fix it. But electric cars are a good example. Of course, a single electric car emits fewer emissions than an ICE car, an internal combustion engine car. However, to replace a fleet of 2 billion cars means to build 2 billion new cars. And so the solution is not to replace internal combustion engine cars with electric cars. It's to rethink the purpose of cars altogether. It's to rethink how much we consume. Sure, future cars should be less destructive than the previous ones, but maybe we need fewer cars, and we need more public transport, and so on and so forth. So I think what ecological jurisprudence offers is the possibility to think ecologically in terms not only of a problem with a solution, but of the relations between what we conceive of a problem and we conceive as a solution. John Michael Greer distinguishes problems and predicaments. He says problems are things that happen that have a solution possible to them, whereas predicaments are things that have no solution, only responses. So, for example, you puncture a tire in a car, problem, the solution is you just change the tires and you keep driving. Aging, on the other end, is not a problem. You can't have a solution to aging. It's a predicament. You can only have a response and an adaptation to a predicament. And I think what we are experiencing today is not an ecological crisis or problem, is an ecological predicament. It's a radical shift in the way in which we are living. And I think a techno-fix solution is the wrong response to a predicament because it's not a problem to begin with. So hopefully that answers the question. I think actually that Chris is talking that we still talk in terms of conquest, quoting Rachel Carson, and that's the dominant language. That's the crude anthropocentric view that we still speak of. Great question. So Hermano is asking whether there is a common language or way of communicating, understanding each other, or a communicating dimension that I have discovered in our study. I think the reference, there's always a reference to a more than human. All human legal orders refer in one way to another to the human. That human might not have clear boundaries from the more than human, many indigenous legal orders, but it does exist. And so the more than human then becomes the common term, the common language, the common term of reference for different legal orders to discuss among themselves. It's that quote that I ended with, the idea of the common ground. The common ground is very tangible. It's the space upon which we walk. And we all engage with lands, waters, skies, and so on. And so that becomes the common language. Not thinking that we see it in the same way, but knowing that we see something other than the human, and then discussing what that is and discussing how we relate to it, to each other as a role. Therefore, yeah. So Stefan is saying that he's trying to link environmental law and rights of nature because I think they are complementary. I completely agree, Stefan, completely. I believe that some authors actually say that there's a tension between pleasure, Mano. Thank you. There's a tension between environmental law on the one hand and rights of nature or ecological law on the other, as if the two are in radical opposition. I don't think they are. I think they are both expressions qualitatively, or the degree, the difference is to the degree of response, but they both ways of responding to an ecological predicament. Environmental law has done it traditionally using more traditional responses, whereas the rights of nature are more radical responses. But they're both ways of responding to anthropocentrism. They're both rejecting the more crude anthropocentric perspective. And none of them fully rejects anthropocentrism. And perhaps that's not even necessary. So, but I completely agree with you, Stefan. I don't think the two are to be cast as in opposition to each other. I don't think it helps to cast them as in opposition to each other. Thank you, Peter, for all the Sarah quotes. They're excellent. Thank you.
Alex, I'm a little conscious of the time. I think we may be over the allotted time, or were you going to go for 2 hours?
I think we had 2 hours, but I think actually we can go with the flow. So if there are more questions, we can discuss more. Otherwise, I think I really acknowledge that people have already spent almost 2 hours in listening to the book, and I really thank you for being here, and really thank everybody for the patience and interest that you've shown. And I hope actually that the book will be of use to many, and please share it with anyone who may think it may help them, may be of use, and either theoretically or practically. The book is intended very explicitly as a companion to wild law. If wild law is the inspiration and the soul, ecological jurisprudence is the analysis and the mind. And so the two actually hopefully work together hand in hand to unveil the journey toward an ecological jurisprudence. And thank you all. If anyone wants to contact me, I'm very keen. I know many of you here. I don't know some of you who attended today. I look forward to meeting many of you in the future and crossing paths more closely in the future. But if there are other questions before we leave, I'd like to thank you, Julie, and please do feel free to do so.
Yes, I see there's a comment about how many environmental lawyers aren't familiar with this. And I think that's one of the areas where your book will make a very big contribution, Alex, because I think it's absolutely true. I mean, I certainly was an environmental lawyer and had studied this. And apart from reading that one article by Christopher Stone that Alex, should trees have standing, none of this was ever raised or discussed. So I think it is quite important that it's making its way into curricula all over the world now, but there's a shortage of really good texts, and I think your book is going to play a big part in filling that gap.
Just one question actually is coming from Krishnan. whether Earth jurisprudence and ecological jurisprudence are the same. No, I think actually in the way I described it, originally ecological jurisprudence was intended just as an expansion, a geographical expansion of Earth jurisprudence. But over time, it became something more than that. Earth jurisprudence is a particular way of articulating jurisprudence or a jurisprudential theory, whereas ecological jurisprudence is a spectrum, a much larger spectrum of articulation that includes Earth jurisprudence, but is not limited to Earth jurisprudence. Earth jurisprudence is a permutation or a way of a tendency toward an ecological jurisprudence, as is environmental law, as is the tendency toward an ecological civilization. Yeah.
Well, thanks for everybody for the very nice comments in the chat. And yes, I just on that Earth jurisprudence point, I mean, I do tend to see Earth jurisprudence very much in terms of the wisdom from this particular planet, although as Alex has pointed out very clearly, you can't really separate it from the cosmos. So the galactic point is valid.
Or universal law, but there's universal jurisprudence, but there's that's even worse than galactic jurisprudence. Yes, I think the idea of pluriversality is absolutely crucial. That's kind of the frontier of legal pluralism at the moment. So I think it's an excellent point that Patricia is making. Obviously, I don't go into the depth, but the legal pluralism does influence a lot my work, and obviously the more recent discussions do so. Thanks, Peter. I look forward to the discussion indeed. And thank Chris also for that connection. Yeah, cosmic nomos, as someone suggests, I don't know whether they want to be named, is also a great way of thinking about ecological jurisprudence indeed. Well, thank you once again, everyone. Thank you for those who participated at 4:30. Thank you for those for whom the evening now is beginning. And all the best to everybody. Happy Earth Day, and may you all have a wonderful journey in this and the many lives to come.
Thank you very much, Alex, and thanks everybody. Thank you for inviting me to be part of this really great discussion on what's still Earth Day for me anyway. Thank you.
And thank you, Cormac, for being the inspiration, being a great friend, a great colleague, and the reason for which this book and this presentation occurred in the first place. Bye, everyone.
Bye, everybody.